facing Mr. Daniels as he entered to his testimony. For instance, photo 11, close up around the neck. Photo 13, that's how he explained to us how he loosened around the neck. Cool. Now, we've got that version, and your client's testimony. If you go back to this exhibit FFF, slide 4, what he said on the 30th of May in this court. The tension around the neck was very tight. There was a lot of tension on the knots. There was no play. She was extremely heavy. It was not easy to take the noose off. You want to comment?
My lady, Exhibit MM, I've just perused it very quickly. Firstly, if I can just go to photograph number 2 on it. There's, from my observation, there's at least, at any one place, there's at least 2 strands, if not 3, from the angle at which I'm observing it. That doesn't reconcile with the observation on Mrs. Rohde. I don't know what, I'll just make comments as I see in the photos. I can't comment on photo 3. Photo 4, again, my lady, I can't comment on which side people are facing, etc. from the autopsy findings. I have to stay away from that. But if one looks at the young lady here in photograph number 4, if I'm observing correctly, it seems as if there's a point of suspension or the knot in the front of the neck. And 5 shows it even clearer. There's something on the front of the neck. Again, if that is the point of suspension, if that's supposed to indicate the point of suspension, it doesn't reconcile with the observations made at the autopsy, and both the first and at the second autopsy, my lady. And
what do you mean by the first autopsy observation?
the observations made at the first autopsy has all the features of a single strand.
You're aware, sorry.
This, what I'm looking at, is mostly double-stranded, but there could be areas in which there's 3 strands. So I'm saying that if I use the observations made on the left side of the neck and the anterior part of the neck and the right side, this doesn't reconcile the number of ligatures as strands. That's what I meant. Then also, if one looks at the point of suspension, if I'm interpreting this right, even in photo 6, my lady, that it seems to me that the point of attachment or the suspension would be the front, if that's what it's meant to portray. My interpretation from looking at the mark on Mrs. Rohde, that point would be on the right side of the neck. So the rest of it in terms of, in photo 11, I think, my lady, shows it quite better, it's a high power, closer magnification. Is on the left side of the neck, there seems to be at least 3 strands now, which, as I mentioned earlier, doesn't accord with the observation. And secondly, it seems as if the point of suspension is in the front. And again, my view is it in the right lateral.
Dr. Perumal, we've heard your theory this morning, or theories. You're a scientist, correct?
Yes.
You're prepared to consider different opinions, correct?
Correct, yes.
Now we've got the opinion from Dr. Khan that in his post-mortem report handed in, you've seen that, his findings on page 3 concludes the cause of death was determined to be unnatural, consistent with asphyxia following manual strangulation, external airway obstruction, and the features of the ligature imprint abrasion mark are consistent with post-mortem application to the neck. Will you reconsider your opinion based on what he sees the features of the ligature imprint abrasion mark? Is there room in your mind to consider that scientifically, that he might just be correct in what he perceives there?
My lady, there was quite a long proposal or question, statement put. Can I just break it up as I understand it?
I just want to add to you, when Dr. Khan testified on this particular point, I asked him what is the placing of the ligature post-mortem means.
Yes.
And he said, simply put, it's as if someone had put the ligature around the neck to make the imprint of a ligature. Not that was the ligature created by how Susan was found. In other words, what Mr. Daniels was saying, the position she was found in.
Okay.
So if you could comment, taking that into account.
Yes. My lady, Dr. Khan's the first one. May I proceed?
You may.
Yes. The first one, he says the cause of death is unnatural.
Mhm.
So I'm agreeing that the death is unnatural. So that's the first point. Consistent with asphyxia? Yes, I'm agreeing it is consistent with asphyxia. The reason I'm saying it's consistent with asphyxia, even though I do not have any diagnostic pathognomonic signs to say this is asphyxia, it's based also on exclusion of other probable causes of death and what we're seeing. So I say it's consistent with asphyxia. My lady, following manual strangulation, I think in my evidence in chief, my lady, I said that there are two scenarios that could be at play. One is that there's ligature strangulation in the form of hanging, and the other one was manual strangulation or throttling. And I was very clear at the time saying that I'm not excluding manual strangulation in terms of the pathology. But I said, given the findings that I made, together with what was documented all along from the scene to the post-mortem, I favored, on a balance of probability, more that it was hanging. But I would not, and I added the phrase, I will not be dogmatic or adamant about any cause of death that I can make from the post-mortem examination. So I haven't come here being dogmatic about anything. I'm simply saying that when we say it's consistent with, means it could be this, but not to the exclusion of other things. That's what the phrase, that's how we use it. If the margin is even narrower, then we say not inconsistent with. It sounds almost like an oxymoron, but that's how we phrase it. So the way I read Dr. Khan saying it's consistent with manual strangulation, and I would read this as we taught in our early stages in life as pathologists, meaning always keep an open mind for something else that can be put to me, and I'll say, well, I'll consider that. So when I said it's consistent with hanging, meaning I'm not saying that strangulation is excluded. Now, the ligature, an external airway obstruction, my lady, I commented on that. I can't say that there was no external airway obstruction. I don't have anything, features to support it. So I can't just say that there's an external airway obstruction without me finding something. And in the dissection that I did, I looked specifically for it, although I wasn't told that there was possible smothering or anything. I just looked for it as part of examination, and I didn't find the evidence for it. Then as far as the features of ligature imprint mark being consistent with the post-mortem examination, my lady, I covered that quite a bit in my evidence, saying the area that's really only blanched is mainly, if one looks at the circumference of the neck, is probably 25%. But from the front, even to the left side laterally, part of the front, the left side laterally, and where the ligature that we can see in the photos taken at the scene do go to the back, but we don't have a picture of the back. That ligature is not a ligature that is blanched. It's not, there's a response and a reaction to it. And the basis on which Dr. Khan was saying that it is a ligature that's applied post-mortem because of the lack of the parchment-like appearance, I said, and I say this respectfully, I think it's an observer error because it is there. Secondly, in terms of the ligature, my lady, I think most pathologists, not all, most pathologists will say that that imprint mark is actually a post-mortem phenomenon.
Which one?
The imprint that you find in a person deceased who hung themselves. Because the oxygen supply shut off quickly, death occurs rapidly, and by the time the convulsions and everything else result in the imprint mark, we are basically deeming it to be a post-mortem phenomenon. Now, the longer the person is suspended, the more prominent that mark will appear. Now, I don't know how soon after this incident Mrs. Rohde was taken down. So I'm saying that if you look at any recognized textbook, you cannot use the imprint of the mark, the appearance of the mark, whether it's blanched or otherwise, or certainly as we see in this case, that we can say that this is a post-mortem application. The features, as I said, my lady, is the fact that it does cut quite deep on the opposite side of the point of suspension.
That the mark is there, is no doubt.
Yes.
What I would be interested in is, could that mark have been imprinted in line with Dr. Khan's testimony? In other words, it's a staged mark. Whether the person is still somewhat alive or has already deceased, is that possible?
I wouldn't exclude it as a possibility, but I'll tell the court why I don't think that is so. The reason, my lady, is if an imprint like an electric cord, if an electric cord instrument is applied to somebody after they've died, all that we will get is just the impression of the cord. But if the person was alive and there is movement and there is friction, even though it's a smooth object, there's friction between that instrument on the neck and the movement of the body, then it will create the mark that we're seeing here. I would expect, if this was applied after Mrs. Rohde died, two things. One, that the the type of mark that we're seeing on the right front, just a blanched area, is what I would expect to see throughout the neck. The second aspect, my lady, is the probability, and some of the authors are quite strong on it, that if you see a drool or dribble of saliva, that's not going to happen if somebody is deceased and then hung up. The mechanism is thought to be the autonomic nervous system stimulation of the parasympathetic that causes the salivary glands now to secrete. So the person has to be alive for that saliva to be squeezed off, if you can call it, from the salivary glands, both the parotid gland, which sits just below the ear, and the submandibular, which is underneath the jawbone, for that to be produced, to come off. The person has to be alive for the autonomic system, nervous system, to operate and create that.
Well, as I understand the evidence, we've got the accused version on the saliva. That might be wrong.
I'm afraid, my lady, I can't comment whether it's right or wrong. I'm just using it. If that is correct, then that's the interpretation. If it's not correct, then this whole thing just doesn't apply.
So if there was no saliva,
Now, if there's no saliva, and my lady, I can't remember the reference, it says, even if there's no saliva, it doesn't necessarily mean that it's a post-mortem hanging. In other words, that the deceased is hung up after death. So you don't, because if you look at the mechanisms of death that I explained in hanging, one of them is the autonomic nervous system. And so it will be present when the autonomic nervous system plays a role. That's why the authors are careful to say, if you don't find the saliva, it doesn't necessarily mean that the person wasn't alive at the time of the ligature suspension.
you said something.
Yeah, sorry, Mali. That's why I was at pains to say the whole conclusion in the case is not for me as a pathologist. It's for the court to decide, is there evidence going to be accepted and how does it fit in with the pathology? So I'm not here to usurp and take the role of the court.
Well, we've got your client's version that she was hanging. You understood that, correct? Partial suspension hanging.
Yes, my lady.
And you said in the last 5-10 minutes, if I had it correctly, and please assist me if I'm wrong, you said words, I do not know how soon after the incident had occurred she was taken off. Is that what you...
That's correct. In terms of minutes, I do not know for what the evidence was in the court.
But I put it to you, that's based on the version of your client, the accused. The state will argue that on the version of Desmond Daniels, when he opened the door, and the accused differs because he said Daniels only unlocked the door and the accused then pushed the door open and there was resistance. Daniels says he pushed the door open and he saw the legs from the knee to around about the ankle flat, both flat. Now, and the state will further argue.
My lady, I think in all fairness, that was one of 3 versions that Mr. Daniels gave during the course of his testimony. And in all fairness, all 3 versions should be put to this witness.
No, Mr. Van Stay, please stop with that. The issue of the legs he was consistent on. I would like to hear what this witness's response is to.
My lady, it was also his version that he saw the deceased lying flat on her back in the bathroom, and that was proved to be dishonest.
I'm referring to the testimony which we heard in court.
Well, the part of the testimony in court was to confirm his affidavit in which he said that.
I will make that decision in my judgment.
My lady, the objection I'm making is that the two positions should be put to this witness regarding Mr. Daniels' version.
Thank you. Mr. Van Niekerk.
Thank you,
My lady, is the court overruling me on this?
Hearing Mr. Van Niekerk's reply. Thank you.
The state's proposition based not only on what Mr. Daniels testified, read in conjunction with his cross-examination, as well as the statements that he made, what he perceived happening there behind the door, what was there behind the door. What I want to put to...
Sorry, I must respond to this. I will allow your question to the witness. I would like to hear what the
Thank you,
witness
my lady.
has.
What I'm putting to you, Dr. Perumal, is that part of the state's argument, the state's case is that she was not hanging behind the door, taking all the evidence into account, not only what Mr. Daniels testified here. Now, if you as a scientist can consider that there's a possibility that she was not hanging behind the door, partially suspended, would you reconsider that last part of the cause of death stated by Dr. Khan? The features of the ligature imprint abrasion mark are consistent with post-mortem application to the neck. That ties in with my lady who put it to you. That was also part of his testimony, Dr. Khan's testimony.
Yes, my lady, as I said earlier on, the fact is that there is a response. There is a braided tissue on the left side. There is a drying up of tissue. That can only happen if there is movement and friction between the instrument and the body, let's say the body or the neck of the deceased, for that to happen. If the ligature, the cord was applied, in my opinion, after the person had died, and just without suspending, then all it will do is make an imprint of a smooth ligature onto the skin without the parchment, leathery appearance that we find. So I do not think, my opinion here is that I do not reconcile that somebody had been throttled and then now a smooth surface ligature like an electric cord wasn't applied. It's extremely unlikely to give the impression of the ligature abrasion as we see it, starting from the very beginning, my lady, at the scene. It's not subsequently. It's taken, photos are taken within a few hours at the scene. That's where I'm making those observations.
Is your interpretation that imprint could only have been made as a result of hanging, or could it have been an application with an anti or post-mortem death?
Lady, as I said a few times, there's no way any witness can exclude a possibility. But what is more likely here, for me, is more likely that the picture that I see of the ligature mark in the bathroom is the best representation of the ligature mark. It's good photographs, good quality photographs. That to me indicates that that is an ante-mortem mark. In other words, the person was alive at the time. But if the description given by Dr. Khan, that the entire ligature mark was parchment, blanched, that description may fit in with the scenario created. In other words, just a blanch appearance. But that's not what I'm seeing in the photos.
Let's move on to exhibit triple F2, slide 3. You've got exhibit triple F2 there.
I do have, my lady.
Please turn to slide 3. depiction of a knot. The first one on the left, have you seen something like that, either by practical experience or in textbooks, consistent hanging?
My lady, yes, the way I see
Sorry,
it,
no, you're not at the page 3.
okay,
Yeah,
yes.
that's it. Thank you.
Yes. My lady, if I can look at the diagram on the extreme left, it's probably representing a slip knot. I don't know if that was the
Yeah.
intention, but it meant to represent a slip knot. That's not uncommon, if not at least 50% of hanging cases, you will see a slip knot.
Good. Then the second depiction there, the bottom, the smaller one.
Yes.
You're familiar with such type of hanging?
Yeah, there isn't a knot there, so I don't know how this would stay on the neck, but I can't dispute that such thing may exist.
Well, without a knot applying force on the neck?
Yes, in other words, to hold the weight of the individual. This will just slip off the person's neck if it's not secured somewhere. I'm not being critical, I'm just telling you the challenges I got in understanding it.
And the right one, sketch there, point of suspension at the tip of the apex, inverted V shape. It may or may not involve a knot, but it's the point from where hanging of the body takes place. Are you familiar with that type of scenario?
Yeah, my lady, I think this would fall under what I initially described as typical hanging.
Then the next slide 4, point of suspension, depictions from what we see in the ABC van Gerechtige Geneeskunde. Are you familiar with that, the standard work?
I am familiar with it.
What we see there, you will accept that. That's the different positions, not all, obviously, but what one can find to make sense out of this.
Yes, my lady.
Slide 5, again, 3 news possibilities. Are you comfortable with the descriptions and how it's depicted there?
Yes, my lady, I think the one on the extreme left is showing a double-stranded, and I think it's still a slip knot. The middle one, the noose, just so that we can all on the same page, I think I said that the noose is the ligature around the neck, the knot is where it's brought together. So this looks like a slip knot again, the middle one, but a single strand around the neck.
Okay.
And the extreme right could be again a slip knot with a single strand.
And one, you've seen this, or been documented.
These are various types of ligatures and knots that can be present in cases of hanging.
Thank you, Doctor. And then the next slide, 2 types of knots, static and glide. Are you familiar with that?
Yes, if we use the word, the static will be fixed, the glide we say slip knot.
And
With the static knots, sorry my lady, they tend not to be very tight around as opposed to a slip knot, because when it slips, the gravity and the pull of the body will make the knot tighter and the noose even tighter around the neck.
And what is described there, tight, the knot is not fixed, it can glide, the noose can get bigger and smaller. With the static one, you agree with that?
That's correct, yes.
And with glide, the knot can glide, the noose can get bigger or smaller.
That's
Is
true.
that so?
Yes.
And then underneath the static one, if you make the noose and the knot before putting it over the head, the whole noose cannot apply tension on the neck. Is that a scenario that can happen?
Sorry, will you repeat that? I just want to make sure I'm following you. Sorry, my lady.
Underneath, what's written underneath the static one, I'm
Yes.
reading that out to you. But maybe you can just read that.
With a static knot, you may make a noose and a knot before putting it over the head. That's true. the whole noose cannot apply tension on the neck. That is also true. To get it over the head means the noose will have to be bigger than the neck. Circumference, yes. This will thus be a play. But that is on the assumption again, and it's not my field of expertise, knots, but then sometimes the person will apply the knot and the noose when the ligature is around the neck rather than forming it over and pulling it across. So I don't claim to be any expert in this field.
Please just finish reading there.
So there will thus be play. To get a noose with a static knot tight around the neck, you'll have to tighten and tie it while the cord is around the neck. And that's really what I was indicating to your lady.
Now, slide 7, would you agree, take your time, possible not to get a knot imprint with a static or not static, double or single strand,
Yes,
with a gap between the neck and the knot?
yes, as long as there's a gap. And that is more likely, my lady, in partial suspension. In other words, when there isn't 100% gravity pull by the mass of the body, you're more likely to get it tighter and not get that gap, that upside down V or U, in partial hanging. Complete hanging, you're more likely to see the whole picture, if I can put it. But if there's a partial hanging where parts of the body are touching a surface, then you're more likely to see this gap that we are referring to.
But that's a theory, correct?
No,
Depending-
it's not just theory. It's in quite a few of the references that Dr. Khan handed in, including Bernard Knight.
Indeed.
Yeah.
However, remember what is the evidence of the accused about the tightness. So if you factor that in,
As I indicated earlier, if the noose was extremely tight, then I expect to see more of the ligature at the point of suspension.
thank you. So we'll put this in a minute. I've got no further questions for you, Dr. Perumal, on exhibit F2. I want to move to something else, and that is, you said you testified in the Super 14, members of the murder and robbery unit that were charged for the death of an individual in their custody. I'm at page 2616, going on to page 2617 of the record. And it's exactly what you did. You didn't do the autopsy. I gave an opinion on the docket and how the individual died, and was called by the DVP to testify in that case. It was in the Cape Town High Court. Correct?
That's correct, my lady.
I want to take you through this judgment. I want to hand it to you, as well as the full copy of Judge Henny's judgment. Case number CC12 of 2012. Judgment delivered on the 6th of November 2013, sitting with an assessor, Chief Magistrate as he was, Mr. van Reenen. Now, the background we can find in his introduction to the judgment, and I want to get to where your opinion is being dealt with by him. But just as background, there were 13 accused,
Oh,
members of the South African Police Force, and on paragraph 2, they took 4 suspects, they took out 4 suspected in the involvement of the crime. wanted to verify the particulars for the purpose of the bail hearing. And paragraph 4, some stage person died called Sitwell. And he was in police custody. And then, as you would recall, Professor Buddy, paragraph 7 of the judgment, he found that the deceased had died of multiple injuries whilst he was in the care of some of the accused. Remember this case?
I do recall it. I don't know when it was.
Now, then I want to take you to paragraph 31 of the judgment on page 10. There was evidence of the secondary nature as described by Judge regarding the murder charge of Professor Vadi, the pathologist who performed the post-mortem of the deceased, and Dr. Perumal, an independent pathologist in private practice, was also called by the state to advance an expert opinion as to how the deceased could have died. Now, let's focus on your opinion. You can refresh your memory. In this matter, if need be, we can deal with it again tomorrow morning. On page 30, paragraph 100, Professor Wadi's evidence is dealt with in the judgment. And then paragraph 102, he concluded that the cause of death was multiple injuries and the cause thereof. You had sight of his post-mortem at the time. I'm not asking you to recall everything now, but you remember, correct?
I recall that I must have had sight of his report.
Then we start with your evidence as put here in the judgment, paragraph 112, where you are introduced as a specialist forensic pathologist and your experience of people who were injured in motor vehicle accidents, correct?
Yes, I certainly do have that experience, yes.
Specifically, as stated there, the second half of paragraph 112, people who had fell out of a motor vehicle, who had jumped out of a motor vehicle. And then, I'm not going to read it out to you. He dealt with how you testified, paragraph 113 through the next page. You differed in paragraph 115 from Professor Wadi, as he described injuries as abrasions. You, as you called this witness, thought differently and saw it as an imprint abrasion. Correct?
I'm following this, but I must tell you, I have no independent recall of this matter.
Well, that's
my
why
lady.
I'm offering you the time to. Then paragraph 120, your evidence was the fractures to the ribs. If one looks at the pattern, it could be that it was caused by something like a knee. And then paragraph 122, where you concluded your evidence in chief, there was extensive bruising caused by blunt trauma. And then your cross-examination evidence was described, where you had to make certain concessions, as from paragraph 123. The condition of the clothing, the next page, page 36, and the description and characterization of the wounds would not have been the same if we had the other photographs of the exact same clothing. Would it be fair to say that
Sorry, my lady, I'm not there at the paragraph. Which paragraph is this, my lady?
paragraph 124, as it
124.
continues on page 36. You follow?
Yes, I follow.
Good. There was that concession in paragraph 126, that same page. He also conceded the wound he classified as an imprint abrasion situated on the chest of the deceased, which he said was in all likelihood caused by an R4 or R5 rifle, could not have been caused or imprinted on the chest of the deceased if he had clothing on. like the jacket as shown on the photographs presented by counsel for the defense.
That's true, yeah. It had to be naked skin.
And then paragraph 127, you conceded that those firearms could not have caused the imprint abrasion on the chest of the deceased.
I'm following.
And further concessions were made, and we can read that later this afternoon, tonight. Paragraph 128, concession that a lot of the bruises and abrasions were on the limbs. Paragraph 129, conceded the injury could have been caused by the brain moving at considerable velocity, hitting up against a fixed object. Paragraph 131, conceded the imprint abrasion could have been caused if someone had been pushed against the gate in front of the house.
Yes, what had actually happened there was the state had given me a set of scenarios and I said it could be as a result of that. And when different scenarios were put to me while I was under cross-examination, and I even said earlier on in my evidence in chief, an expert, having now been given more information, will have to consider that and make a concession, and that's really what I did. So I had a certain set of facts, if I can recall, and when I was being cross-examined, the advocate, Francois van Zyl, I think it was.
That's correct.
Yeah. He put a whole lot of other scenarios to me. I had to consider it and not be adamant or dogmatic, but just say, now that I hear this, I concede that that's possible. So I've got a little bit more recall of the matter now.
Okay.
As we
But
go.
I'll give you a chance to read through this judgment thoroughly. Then, in paragraph 135 on page 38, mention is made of Professor van der Spey, also testified on behalf of the defense. Recall?
No, I wasn't. I just came. I was called by the state. I gave my evidence and I was gone. I don't know what transpired during the defense case. I've got no recall that Professor van der Spey was called.
Right. Then on page 53, it stated paragraph 201, the case of the state, therefore, in relation to this charge, was to be decided on the expert evidence of Professor Wadi and Dr. Perumal, which in itself is nothing but circumstantial evidence, especially in the form of the post-mortem findings and conclusions of the experts as to the cause of death of the deceased. On the other hand, there's the evidence of accused 2, 5, 7, 8, 11, and 13, as well as the evidence of Professor van der Spey.
Yes.
In paragraph 204, the court makes the following finding. Dr. Perumal, in his evidence, was more direct, concluded some of the injuries was caused by the deceased having been assaulted. He was bold to infer from the photographs he had that one particular injury to the chest area was as a result of a person being typically injured with the butt of an R4 or R5 rifle.
That's correct, yes.
Then, as I said, I'll give you an opportunity to read through this. You don't have to comment now. It was also stated in paragraph 205 that neither yourself or Professor Wadi, apart from being informed in general, it was alleged the deceased had jumped from a moving vehicle, had any knowledge about the particular circumstances and the area where this alleged to have happened.
We were not informed prior, sorry my lady, we were not informed prior to coming to court where this incident took place. It's only during my cross-examination information was put to me and I had to entertain that information and say, given now this new information, that this is possible.
Then the court made the following observations. Paragraph 207, Dr. Perumal's opinion is at odds with that of Professor van der Spey, who was of the view that it would be unlikely that such an injury would be sustained where a person would be lying on his back and someone would press with the knee on such a person. Paragraph 208, in my view, in the absence of any evidence to support the conclusion of Dr. Perumal, it would be difficult, especially in the light of the evidence of Professor van der Spey to conclude that the rib fractures and the underlying internal injuries could have been caused by a knee pressing down on the rib cage of the deceased. Paragraph 211. The opinion of Dr. Perumal about the presence of imprint abrasion on the chest, which was caused by R4 or R5 rifle, proved not to be as convincing when it was shown to him that the R4 R5 rifles were the, which the accused had in the possession on the night in question could not have left such an imprint.
Yes. Now, generally, the butt of an R5 rifle can vary. I've seen an imprint in that particular case of the butt of an R5 rifle making such an imprint bruise. But when they came to court and showed me their instrument, I made a concession that that weapon doesn't fit, doesn't reconcile.
Right.
So I had a certain view based on what I had before, but when I came to court and I was given more information, I had to entertain it and make the necessary concessions. I think that's what the judge is saying here.
Good. Now, I don't want you to comment further on this. I want you to have a look at it overnight, read through it carefully, and if there's any further comments you would like to make on the judge's findings, you're welcome. When we resume tomorrow with leave of the court, we can deal with that then.
No problem, I'll do that, my lady.
The next aspect I want to deal with is the thyroid cartilage bone, that it's incision or fracture. Now, what the state has done, sorry, my lady, I'm reminded that we should mark this judgment as an exhibit.
Where we are now?
That would be triple R.
So marked. Thank you.
I would like to hand up its photographs that already before court, but it's magnified. It's a bundle, and I'll mark it just now. The numbering is not on it. My lady, at this stage, in fairness to the witness, I would like to ask for adjournment until tomorrow morning. I want him to look at the judgment, and I would also like to have him look at these set of photographs that I'll number. As I said, it is already before court, but this is in magnified fashion before I proceed to ask him comments on this. Would that be possible if we can adjourn at this stage? See, it's almost 3 o'clock.
Thank you, Mr. Van der Spey.
I'm going on with that.
Thank you. Mr. Perumal, Dr. Perumal, will proceed tomorrow, the 20th. Mr. Rohde, we will proceed tomorrow. Your bail is extended on the same terms and conditions. If you could be here by 9:15. Thank you. Call is adjourned.